From the difficult system of the healthcare system in Germany in the 20th century, we'll hop right into modern times, which is digitalization and data protection, which is my field. And actually, as a side remark, I'd be really interested to learn how the situation is in Israeli law on data protection issues. It's become a new field basically in the 1970s, and in the course of the first establishment of data protection laws as such, we saw a new legal regime that was created and that has many peculiarities, and one of them, at least by German and European standards, is that we do see that we have both private and state data processing being controlled by the same legislation, at least until now, which in itself already is a specialty of overlapping jurisdictions, but I will concentrate on a different field here. Just let me give a very short overview so that we all have the same basis on which we're discussing this. What happened was that we saw a new technological development that was regulated and that reacted to changing the world, basically, which in the 70s nobody thought so far. And that was data processing as a technology and digitalization and its effects. What happened was in 1995, there was a European Data Protection Directive which regulated this on a European level. Until then, we had seen in about 7 or 8 of the member states that they did not have any data protection laws whatsoever. So in reaction to the directive, they did create their first legislative efforts. Of course, and this has been the reason for a reform that was just passed on the 21st of December, basically, for a new data protection, and this time not a directive but a regulation. The interpretation and the legislative standards which were adhered to in the member states are quite different. And until about 2-3 years ago, the European Court of Justice and the Commission were very reluctant to bring these issues up. So what we saw was a development of very, very different standards. That's the background, basically, on which I will develop my ideas on overlapping institutions. When looking at the directive, the legislation accepted, of course, that there would conflicts be arising over the rights of the data subject on the one hand and the person, the entity doing data processing on the other side. And the directive established in principle, and that's the interesting part, without actually realizing that, 2 different mechanisms of conflict solving. The following remarks that I will do will describe these parallel axes and the enactment, and then show what are the differences, and this is the part where I will reconnect to our health system, basically showing what are typical effects, characteristics, traits, and the effects, basically, of those 2 overlapping institutions. What also comes into play is that, as I said, the ECJ was not very active, but it became active starting in 2014, and one of them, which might have also reached more than just the borderlines of Europe, was the so-called Google Spain decision, which required Google as a search engine to follow the request for erasure of an information that was true and valid, but outdated. And that has brought another player into the field, and this is where we can see very similar things happening as with the Imperial Committee. So we'll see that. What are my next steps, or how am I going to do this? First, I'll describe the structure of control as such, show these parallel jurisdictions of civil and administrative courts and court proceeding on the one hand, and then I'll show the interdependent interaction organization within these 2 steps that Peter has used as analytical tools just as well. So we'll see state and non-state actors acting combined. We'll see norm setting and administrative task going hand in hand, and we'll finally see that there's internal and external uncertainty on the competence who really has the responsibility and the competence to set law and to interpret law bindingly. The system of control described here is one in which we have the regular situation in law, which is there's a subject who claims something on the basis of a certain law and then requests the other party to follow that claim. And as we all know, otherwise we wouldn't have a job to do, that's not always adhered to, so the one party disagrees that there is such a right request and then refuses to follow that. In data protection, that can be and often is the data subject's right of erasure of data or correction. There's also on a lower level the possibility to request simply the information, what is stored at the data controllers, on the data controller's side. I will restrict myself here on claims against private persons, so not against the state. And I will look mostly on the erasure of data, not on information, but it all goes the same way. It just makes it easier to argue. The first mechanism of conflict solving that we can see is making use of the established judicial system and following the established routes within the division of power. What we have is the member states, they are required to provide for regular judicial remedies for any data subject against all types of breaches of its right. So what we have is that we have a data subject who requests erasure against a data processor. The data processor doesn't follow, so what does the individual do? It's a private lawsuit. They go to private court and request it there to have their personal data erased. That's the usual thing, but we also have a different set of control that the directive set up, and that is that the directive requires the member state to establish mandatory supervising state authorities in each and all of the member states. And these supervisory authorities have a very special position. They are given several powers against the data controllers, among them the right to inspect, which is something which the individual does not have, and the right to demand adherence to the existing laws, and they may even express further than that the demand to erasure or correction. And also, we have a direct duty of the supervisory authority to hear claims that are lodged by the individual data protection subject. And this is where the overlapping jurisdictions come into play. On the basis of the information, the authority may then enact its authority, and the directive even provides for legal remedies against data protection breaches. If a data protection authority does not follow the claim of the data protection subject, then the subject may go to court and request the authority to act. And this is where now all of a sudden we have those two control mechanisms come into play. The ECJ now has strengthened this position of the supervising authority in several decisions that were prior to 2014 already, strengthening its independence. And the court has stressed several times that these independent authorities have to be established outside the general administrative hierarchy, diminishing the state influence and the state control over these supervising authorities. So basically they're taking out of the regular administrative system, and in Germany this means taking them out of democratic control. Because now we don't have a hierarchical situation in which the Secretary of Information, or wherever you assign the competence for, is able to direct supervising authorities to act, for example, act in favor of claims by private persons. For a private data subject now, there are basically two alternatives how to proceed if a data processor does not follow its claim. It may address the issue in a civil court directly, or it may address it towards the supervisory state authority and then request the authority to act. If the agency does not do so, then it may have the agency's decision tested in court. And this, however, would not be a civil court, but we have a differentiated court system. It would be an administrative court. In the result, the same legal conflict can be brought both into the civil arena and the administrative arena. Now, what happened in the ECJ Google Spain case was that Mr. Gonzalez, the Spanish data subject, had brought it to the administrative courts, or it was a bit difficult, but to make the story short, it ended in the administrative court, basically. So he opted for involving the authorities rather than going directly against Google. And we'll shortly see that this was rightly so, because he probably would have never won the case if he had gone into the civil court. That is because the effect of these different venues cannot be underestimated. It starts with the applicable procedural law in court. In administrative courts in Germany, we see that it's the court who determines the facts, and he also has to do all of the discovery procedures, while in the civil court, each party is obliged to establish the factual side of its claim. So if Mr. Gonzalez had gone to civil court, then he would have had to prove what Google was actually doing, while in an administrative court, in the administrative setting, it was the authority and the administrative court. And that's a matter of finances, of course, and also of what you can actually assess. It may create the deteriorative effect if you were restrained to the civil court that private citizens would not follow up their claims against data processors because they think they don't have much of a chance to win the usual David against Goliath principle. And the other thing is that the regulated system of lawyers' fee in Germany is immediately affected because lawyer and court fees are very differentiated whether you're in a civil court and administrative court. It also has an effect on substantive law. One would at first sight expect that both courts basically decide the same thing, but the way that courts look at it is a different standpoint. Administrative courts will have a more administrative and constitutional law perspective, also a more European agenda type of setting, while civil court looks at this from typical civil perspective. And we have conflict of laws. That might also lead to different applicable laws. And we've just seen recently an ECJ decision which clarified under which conditions which law has to be applied if there is the authority involved. One of the problems was, what do you do if you have a data processor who is established in one country but exclusively does all its data processing in a different country? And can then the authority in the second country enact any measures in the first country? This is one of the open issues which the ECJ decided, saying that yes, they may act, but if they want to enforce in a different sovereign environment, then they have to make use of whatever there is here. This could have been easily the case in the Google Spain case as well. Mr. Gonzalez could have used this to do a bit of forum shopping. Google had always argued that it's not Spanish law that's applicable, but Irish law, and if it had been preferable, which it happened not to be, he could have might as well just gone up to the Irish courts, which for an individual, of course, makes it even more difficult because who of us knows what Irish law really is like. Stretching this out, I'd like to now connect to, or reconnect to Peter's thoughts. What can we see here for the criterion that he's brought up? The first one is that what we see a lot of times is independent interaction and organization as a problem, and also a chance maybe in overlapping jurisdictions. What might have been meant as an assurance in my case for the data subject to have more than just one option pursuing the rights can also create a huge conflict in regard to the interpretation of material law and the outcome of the suit, and therefore also the development of the legal system as such. Let me start with the assignment problems between state and non-state spheres. That's one of the criterions Peter already mentioned as being typical for overlapping jurisdiction. So whether the conflict is a state-involved conflict or a non-state arena type conflict. Data subjects claiming a violation may first pursue them in a non-state environment, meaning that it's a direct interaction between them and the data processor. But they can also skip that step and directly address state conflict solving mechanisms, especially using the supervisory authority. Peter showed how that took place within one big self-regulatory body in the health system. Here we have it on a more parallel way of choosing between two conflict-solving structures and arenas. So if you choose to have the data protection conflict set up in the state arena, then you have particular rules that are not in the same way applicable if you set it up in the private arena. Whether you have to first address the private arena and then only may enforce it in an administrative court setting or not is not clarified whatsoever. Second problem is we see norm setting and administration interact and not be clearly dissolved. In data protection law, if you look at it from first sight, you don't see that there's any intermingling between the three powers, and basically it's just the general setting. We have legislation on the EU level and the member states level. We have a couple of administrative agencies involved on the member state level, and that's basically it, and then we have the courts performing their regular tasks. But one thing is that the authorities have been established as being highly independent. Secondly, they have been granted the right to establish certain general rules how to interpret the law. And thirdly, because of the very reluctance of the ECJ to control for EU law, which would have been the original task on interpretation of the EU directive in a broad and overreaching manner, in the same manner in all of the member states, what we saw is that the regulatory authorities became sort of a second legislation, declaring basically what their idea of the individual law is. And this has been taking place in all of the member states on a different level. So the Irish pseudo-legislation in the supervising authority decided very differently from the German one what is the law, which is why Facebook, Google, etc. set up office in Ireland, not in Germany, or went to Luxembourg for tax reasons. It's a different story. We have solved, I'd say, the Ireland versus Germany thing now, but we're still working on the tax part. But I'm not talking about taxes, sorry. There are two movements now with the ECJ Google Spain decision which strengthen this or create more problems now. The one is this independence thing, that the ECJ made the supervisory authority highly independent. So in the course, data protection authorities are now what you could call self-standing, and they cannot be controlled. So if they establish something is the law, you have absolutely no remedies in court to have that controlled unless you bring it up in an individual case, which is something which we, at least in German law, so far do not accept. They usually have the possibility either to directly address whether a law is unconstitutional or something, and if you have rulemaking on a more general level, on the administrative level, then there are also ways of having that control. There's no procedure set up to do that with the independent authorities that we see in data protection. So what we miss there is not only the democratic backbone, but also the controlling issue. And that, of course, is something that all goes into the administrative court where the supervisory authority is involved. It would not be of importance in a civil court where the supervisory authority would not be involved whatsoever. Second is what happened in the aftermath of the Google Spain decision. It's a highly complicated situation in which you have to decide as Google or any kind of intermediary whether you want to erase some information or not. And some have criticized the ECJ for not being more specific. I personally like the idea of judicial restraint and leaving it up to the discussion to take place in a couple of years, how you want to balance the rights of the individual, the rights of society, the right of personality, the right of privacy on the one hand with the right of public interest, public information access, the data processors, business rights, of course, and media rights, publishers' rights, whatever there is. I mean, it's terrible, basically. Now, Google was the one who had to decide and who had now all these requests on their desk. So what did they do? They established the so-called Google Advisory Council. It's made up of 10 members from a diverse background of countries. Their data protection position is very diverse. There were people like the former German Ministry of Justice, who is an avid proponent of data protection. There have been also others, and Eric Schmidt came by a couple of times to make sure that this was his position, that there should be broad access to all types of information. Also, political interests were reflected in that council. So what you could say is kind of a trying to reestablish or recreate societal influences within that advisory council. That council was then requested to draw up guidelines under which Google would then decide how a request of erasure would be handled in the light of potential infringement of other rights. As far as it is known nowadays, Google in principle does act according to these advisory council findings, and so the private player has now established a procedure that includes a variety of stakeholders, their interests, and has established a rule under which such a request is actually granted. And as Google is the major player in some of the member states, Google has somewhat of 95% of the market share. You can imagine that being a very small, upcoming little search engine. What do? You're not going to set up your own little advisory board council, but you just take over what Google Big Brother has found for you. And then you live a happy life because everybody will concentrate on fighting Google and not concentrate on your erasure request. So what we see here is basically a private actor taking over the position of the pseudo-parliament in the construction and in reflecting democratic settings or societal settings, and acting as a lawmaker for the entire guild, basically, of search engine and intermediaries without rules of representation. None of the others search engines, for example, was involved in that rulemaking process, and there were no state actors involved. So there's no influence, no control. There's no possibility of legislation to directly influence or even overrule these settings, and it's a standard that's been set within the industry rules as such. So what we see that the clear attribution of powers and functions all of a sudden is diminished, and what we see is that private actors, and that's very closely to what Peter was saying for the end of the 19th century, is also taking place once more beginning of the 21st century. Final thing is uncertainty of competence, a third criterion Peter already mentioned. Data protection authorities like to claim, at least some of them, those of them that have a certain feeling of their power, that it is their original power and competence to enforce data protection laws, and also to interpret them in the first instance. So they believe that any claim before going to court should first be presented to them. Their interpretation of the directive is the directive did not open up the civil courts, but it gave the supervisory authorities the power to enact the directive, and therefore the first step before going to civil court is involve them, and then going to administrative court. The directive in its wording has absolutely no ground on which this can be based. It establishes basically two venues and two competences. So now, how do I solve that problem, and what do I do as an individual person who wants to bring forward my claim for erasure of data? The ECJ's Google Spain decision made that situation even more tense, because all of a sudden now the balancing of data protection rights with other rights has to be considered, and it's become an open criterion all of a sudden. People have not been thinking in these matters before a lot. If there is the Google Advisory Board setting up certain rules, there's also a certain standard that some of the regulatory authorities have set up, saying that a request of erasure should be granted on these and that and those conditions. So what we have all of a sudden is the establishment of different substantial law by two authoritative bodies that both believe they are the originators, or they are the ones who have to decide and have the power and the competence to decide. So what we see is that the data processors and the proponents of public interest certainly refuse the data authorities' standard setting, saying that they don't have the competence to do so. This, of course, can even be more problematic if you look into EU law, where you have the EU Charter, which differentiates between privacy and data protection, and we don't really know what the difference is so far. So competence over who decides and who has the first right to access whom in a conflict can be observed as well, and is certainly not solved. So let me conclude, basically. What we showed is two different concepts in two different time frames, two different regulatory regimes. At first sight, they seem as far away as you can think. Health system, don't take this personal, seems to be a bit boring. Then we have the exciting world of Googles and Facebooks and everything. But on the second side, we see that we encounter actually very similar structures. We see that the Google Advisory Board might be the first significant step to end up in something very similar to the structures in the health system. We see that there are huge assignment problems between state and non-state actors, between the roles in a division of power and a division of court system. And we see that there are parallel competences and jurisdictions that allow for very strategic decision-making and a sort, and this is where I connect to Albrecht, basically a type of forum shopping, which is probably not what was intended, and certainly might not really help in solving the problems that we have in a globalized world. So thanks a lot for the attention.